Hi, this is Jeanette Jifkins. I'm on the road in between meetings today and just thought I'd share a couple of stories with you. One, I was speaking to a friend earlier and they said, oh look, that's such a great story, more people should know it. So I thought I'd share it with you today. I had a client who received one of those nasty letters of demand in the mail saying, you're in breach of our trademark, hand over your domain name, hand over your website. If you don't do it in 24 hours or 7 days or something ridiculous, then we're going to take you to court and sue you for a whole bunch of money. Now, the client came to me and said, can you represent me in court proceedings? And I went, hey, let's stop and look at this at a moment and see if that is your only option. And when we looked at it, the value in the client's business was not in the trademark. So this is a client who had been selling a product that they imported from the UK, and the company in the UK had registered the trademark in the UK. There was a competing company in the US, and they had registered the trademark in the US. Now, the American company came to Australia, they registered the trademark in Australia, they waited a couple of years, and then they wrote this nasty letter to my client saying, you're in breach of our trademark. My client had been trading here before. There are a whole lot of legal technical arguments. We could have gone to court, we could have argued prior use and all sorts of things, but court proceedings take time and cost money. So the prospect of my client going to court was just not attractive. We were looking at maybe 3 years, 150 grand, and no guarantee of a result, or no guarantee of a favourable result. We wouldn't have got a result one way or the other, but we couldn't guarantee it would help my client. So looking at the business and knowing that the value wasn't in the trademark, we spoke to the supplier in the UK. They were happy to rebrand, or they were already in the process of rebranding some of their products. So they said, okay, what we'll do is we will assist you in rebranding. They registered a domain name with the new brand. They registered the new brand as a trademark here in Australia. And my client put together a 90-day plan, or at least I helped my client put together a 90-day plan to rebrand their business and to shift everything across to the new brand. And because it was a 90-day plan and we made some promises to the American company that this is the process we were going to go through, they gave us that time, because 90 days is a hell of a lot better than going through court. And there are certain requirements and rules around proper negotiation and all that sort of thing in trying to reach a commercial resolution. So they just had to wait. And in that 90 days, my client shifted his entire business onto the new brand. Now, the value was in his database. So through a series of communications with the database, the whole database was shifted across to the new brand. My client did have to spend money on rebranding and shifting the database across, but he didn't lose any revenue. And most importantly, he didn't lose any business. So once that process was complete, my client had a new website up. He had the entire database marketing to and was changing them over to the new brand. We got an agreement with the American company to say that we could sell out the end of the branded supply and not stock any new supply with that trademark. And in the end, the American company bought my client's domain name. Now, the reason behind that was the domain name was a .com, which means it can be used internationally. So my client still had the right to use that domain name in jurisdictions other than where there was a registered trademark. So he could still use it in the UK where they had the registered, or his supplier had the registered trademark and was happy for him to use it. So in order for the American company to get hold of that domain, they had to buy it. So instead of 3 years and $150,000 in court with no certain result, what we did is introduced a strategy whereby my client rebranded in 90 days, shifted his business across, didn't lose any money, and because the domain name was bought, his legal fees were effectively halved. So great result for the client, and just a really good example of the fact that there are options. Don't think just because you get a letter of demand that you have no choice but to go to court. And don't think that you might not have an argument, because there's a whole lot of technical issues involved in legal cases, and sometimes it's not all against you and sometimes it's not all in your favour, but there are options, and it's worth investigating what those options are before you go and get started. If you need any help in that area, just give me a call. Jeanette Jifkins. Thanks. Catch you later.